it meant and to cross-examine them. And the judge was refusing to permit us to have that. And while it was still under his consideration, the plaintiffs then, as they always do, withdrew the case so that we'll never get to take Media Century's deposition. Want to know why it probably was withdrawn? Because Media Century is under investigation in various states for criminal violation of being an investigator without a license. And there isn't a lawyer in the United States that would not advise his client under such circumstances to take the Fifth Amendment. While there is a criminal investigation going on, you cannot allow them to testify at a deposition in a civil matter. So I got further than anyone else, but now the RIAA is dropping the case, and they're claiming that it's my fault and that they shouldn't be liable for attorney's fees because my client, who's a home health aide who's never even used a computer and who barely speaks English and who's never even used a computer in her life, and me, it's our fault that they sued the wrong person. So, so how can the technical community help? We need expert witnesses who will work the way the lawyers are working, either pro bono or at very reduced prices, on the internet, on peer-to-peer file sharing, on this whole Media Century investigation, to show, and if you read these materials about the deposition, you'll see what garbage it is. They admit that their process has it's never been peer-reviewed, it's never been tested by anybody. In any normal case, they would never be allowed to put that kind of junk into a courtroom. We need people who know about computer forensics, and who, especially a hard drive, because they go around and they take these judges who know nothing about technology and convince them of crazy things. One elderly judge, they convinced him that the metadata in the files proves that they were illegally downloaded files. In another case in Texas, they convinced the judge that because the computer automatically scheduled defragmentation of the hard drive, that proved that they was trying to hide the evidence. That was spoliation of evidence, and the judge believed it. We really need the experts, but the people can't afford experts. Every day I'm communicating back and forth with lawyers, so we need reasonably priced or pro bono experts to help out with these things and on the forensics. And we need, some people might not be expert witnesses, but they can be consultants and work behind the scenes with the lawyers who don't know the technology well enough to help us prepare for depositions, to prepare and to ask the right questions, to ask for the right documents and data. We also need the tech community. Somebody has to take the initiative, I hope, to set up some kind of pool of people, because the RIAA is fond of using trolls and shills. And I am very reluctant to take someone who I only know through an email or through Slashdot and to actually, or even through Grok Law, which is a very high caliber of people there. But there are trolls all over the place, and we certainly don't want to hire an expert who's working for the RIAA secretly. So the Free Software Foundation has done a great job for us of setting up a fund, an expert witness defense fund, where whatever it's a 501c3, so it's tax deductible. Anybody can contribute to it, and the money can only be used to pay expert witnesses and consultants helping defendants in these cases. Not much money has been put into it. It's insane to me that big companies that make all kinds of money from the internet haven't done anything to help the poor people fighting these cases, because this is the front line. And the internet's at stake. And now I turn you over to my friend Z May, a web developer and tech consultant, and most importantly, a good friend.
Okay. Okay, thanks, Ray, and thank you everyone for joining us today on this little talk. I'll just speak briefly about my involvement with with these cases. Let me just plug in my Mac over here first so you can see what some of the visual aids that I have. All right, so my involvement with Ray started about 3 years ago at the onset of the UMG versus Lindor case. As Ray mentioned, she's a home health care worker who doesn't speak English, if I'm, is that correct?
Not well.
Not well.
Can you put the light back on?
It's not so important yet. I can read it back to you guys. But let me start with a brief background. So this woman who basically got sued for file sharing a whole bunch of songs. A lot of them are like hip hop songs and rap and stuff like that. Like the usual story of an elderly person getting sued for file sharing things that she probably has no idea about. So let me start with some of the sort of the quotes from industry figures and what they say. You know, some of the things that they characterize people that use MP3 devices. So Doug Morris, let me pull up a picture of him here. This is Doug Morris. He is the CEO of Universal Media Group, and he says about people that have MP3 devices, basically, we're thieves. You know, these devices are just repositories of stolen music. You know, that's what he says. That is completely insane. I mean,
Put stolen music in it, it is, but that's like saying that a bag is a repository for stolen merchandise. I mean, it can be, but
right, of course. You know, but this is how he characterizes people that have iPods, creative MP3 players, Zune. Right. Right, most people, you know, yeah, there are some people who put on songs that they download from somewhere illegally, but most people just put their CDs on. They don't want to carry around a whole bunch of discs in their bag when they go out to take the train or whatever it is. Right. So this is another quote from Jennifer Parisser, who is the head litigator for Sony, and she says when you make a copy of your music, that they can say you stole their song. This is how these industry figures are characterizing people that have MP3 players and music lovers. This is how they're characterizing us to the press, to the courts, and to the general public. And I think this is wrong. You know, it's very destructive, and it's very hurtful to technology and innovation. To say that iPod is just a big repository for stolen music is just insane and absurd. Okay, so that's Doug Morris, who's the big bad guy. This next guy is, this handsome fellow, is Dr. Doug Jacobson, who is, okay, I don't know if you can see the whole entire screen here. Let me just go back a little bit. Okay, he is the expert witness, or the so-called expert witness for the RIAA. He is a University of, I think it's Iowa here. Yes, Iowa State University computer scientist, so-called expert witness in these RIAA cases. But I use the word expert very loosely because he has no credentials whatsoever. He is not certified by any professional body. Let me pull up his deposition here. So I was at, so as Ray said, we are the only ones that have actually deposed a RIAA expert. And let me see where, here we go. So as you can see here, Ray asked Doug Jacobson, by what body are you certified as an engineer? And his response was, by no professional society. You know, is there any organization that has certified you as an engineer? His answer is no.
basically he's a bullshit artist.
So basically, he's a bullshit artist. So he would fail the...
And a bad liar. Too.
And a bad liar. Let me get to that. He will say anything that the RIAA wants him to say. He's basically a whore. He'll make up He'll say anything that will get him paid. You know, he's not a computer scientist. He's not a credited member of the scientific community. You know, so are you a member of any peer-regulated society? Are you recognized by any industry groups? And he says, no, I do not have a professional engineering license. So he's basically a bullshit artist. And the scary thing is that he teaches classes on this stuff, on engineering and networking. But back to his sort of his lack of credentials in the Daubert test. So in court, maybe Ray can explain this a little bit better since he's the lawyer and I'm not. Expert witnesses basically have to fulfill certain requirements to be considered experts and to have their testimony admitted in court. Basically, one requirement is that that their results and findings are scientific and that their methods have been subject to peer review and scrutiny by the tech community. And Ray, what are some other Daubert kind of things that?
They're supposed to be testing. They're supposed testing for false positives. Supposed to be publishing, peer review. It's supposed to have been taught by an accredited body. He testified that where did you learn it? I taught it to myself. Has it ever been published? No. Has it ever been peer reviewed? No. Has it ever been anything? And the answer was no to everything. And then when I asked him about Media Century's methods, I asked him the same question. He didn't have any clue, and of course they never have been. And the judge ruled that he could testify anyway.
So he's basically a paid liar for the RIAA. In all these cases, he's their expert witness. Is that right, Ray? Or most of these cases? All.
At this rate, maybe the other side next time should bring in a house plant as an expert witness. Maybe he'd allow that too.
Probably. Some of these judges are very, very tech illiterate. They're even hostile to some of the things that we ask for and the things that we say.
What he does have going for him is he's a partner with a company that manufactures the Audible Magic filtering software, which is being sold to the universities and other LAN operators as a way of getting the RIAA to stop suing. So in other words, if he didn't get a penny as an expert witness, he's making a ton of money from the threat of these lawsuits. They got Ohio University. They targeted Ohio University as one of the universities they were targeting. And then when Ohio University agreed to write out a check to his business partner for $76,000, with $60,000 for the software and $16,000 for the first year's maintenance, no more lawyers, no more letters, no more DMCA notices. So this guy is going around helping the lawsuits, which help make him all kinds of money.
Right, so it's in his self-interest to keep spewing these lies and selling this software that basically is just voodoo. We don't know what it does. He says he's the chief technology officer of Palisades Systems, which makes this Audible Magic network detection kind of algorithm or software, which would monitor P2P networks on campuses and schools and that sort of thing.
Can you say modern snake oil salesman?
Yep, that's what I would say, or a whore. And if you try to actually go to his homepage, it doesn't actually, there's nothing in there. So maybe he took it down for fear of us kind of hacking it or making him look bad or just seeing his bullshit, basically. In the back, someone has a question. Yes.
Excuse me.
Yes.
Excuse me for being naive. If I'm in jury selection and I find a juror who I believe is either compromised or in any way going to jeopardize the outcome of my trial, whether I'm the defense or the DA, the prosecuting attorney, I have a method in which to eliminate them from the jury. Similarly, if I can prove a witness is unreliable or, et cetera, et cetera, et cetera, there are methods I assume that I could use to make that witness not believable. Why is it the case that if all these things are supposed to be true about expert witnesses, that this